guys, for those of you who don't know me, my name is Linda, and this presentation will follow on from a group report I helped complete which analysed the case of Fraser Kirk versus David Jones. For the report, I worked with Alexandra, Kim, PK and Kylie. My role was primarily to complete the introduction, discuss any legislation that applied to the case, as well as find other similar cases that we could draw a comparison from. Like all the members, I also contributed my thoughts to the group opinion, in which we questioned Kirsty's intentions, as once a settlement was reached, she neglected to do all the things she said she would, like donate money to charity and help other women who had experienced similar things in their workplaces. We also questioned the ethics behind Mark's $1.5 million payout and the complaint procedures and protocols in place at David Jones. So the case of Fraser Kirk versus David Jones explores sexual harassment in the workplace. An employee of David Jones, Kirsty Fraser Kirk, made allegations of sexual harassment against the CEO of the time, Mark McInnes. During the course of her employment, Kirsty made multiple complaints to management about Mark's inappropriate sexual behaviour towards her. But after they failed to address the issue, she lodged a statement of claim to the federal court. During these proceedings, Mark held the view that his sexual advances towards her were reciprocated and that was simply the nature of their relationship. Initially, Kirsty was seeking out $37 million worth of damages, which she claimed she wanted to use to help shine a light on sexual harassment and help other women in similar situations. However, the case was ultimately settled outside of court, with Kirsty receiving an $850,000 payment from David Jones. Following the case, David Jones made a termination payment to the CEO, Mark, and that was for $1.5 million. As I mentioned before, my section of the report involved identifying and discussing the relevant acts and legislation to the case, which I found to be the Fair Work Act, the Sex Discrimination Act, the Equal Opportunity Act, and the OH&S Act. The Fair Work Act protects employees from unlawful action covered by anti-discrimination laws such as the Sex Discrimination Act, therefore legally protecting victims like Kirsty from sexual misconduct in the workplace. This complements Section 93 of the Equal Opportunity Act, which states an employee must not sexually harass another person employed by his or her employer. Mark McInnes was therefore in breach of this act. As per the definition provided in Section 28A of the Sex Discrimination Act, we can say that Kirsty experienced sexual harassment at the hands of the CEO because Mark's advances towards her were actually unwelcome. And having known this, David Jones was at risk of being found vicariously liable for Mark's actions, as per Section 110 of the Equal Opportunity Act. Kirsty was claiming that her complaints were neglected by David Jones and that they did not take all reasonable steps to prevent Mark's misconduct from reoccurring. But luckily for David Jones, settlement outside of the courts meant that they successfully avoided vicarious liability. Finally, the Occupational Health and Safety Act details the duty of care employers owe to their staff. Similarly to the Equal Opportunity Act, employers can be found liable under this act if they fail to effectively exercise their duty of care. In this case, the breach would be the senior management at David Jones disregarding Kirsty's allegations and failing to follow the appropriate procedures to investigate her claim against Mark. Although we didn't mention the Fair Work Act extensively in the assignment, it ties in with other legislation that we discussed, such as the Sex Discrimination Act, as it talks about what protection is provided against unlawful action, such as the sexual harassment Kirsty was exposed to. I've come to learn that this act prohibits termination of employment on the basis of race, colour, sex, age, physical or mental disability, and many other characteristics that I won't get into. However, the relevance of this was minimal to the case of Fraser Kirk versus David Jones, especially when compared to the Equal Opportunity Act and the OH&S Act, as there was a significant need to address the vicarious liability of David Jones and the long-term effect of the harassment on Kirsty. If the case was one where the employee was terminated as a result of speaking out about the harassment they experienced, then the Fair Work Act would come into play a bit more and hold greater precedence. That brings us to the end of my video. I hope you enjoyed, and I look forward to hearing your feedback.